My grandfather used to say that the two best investments in life are education and property, because once you have them, no one can take them away. Nice idea, but it's only half true. In some cases, the government or even a private company can claim eminent domain and begin the process of land condemnation that would allow them to take your property away. Hi, I'm David Henson, Managing Partner of Henson Fuerst Attorneys, serving all of North Carolina. Whether you just bought a plot of land a few years ago or your family has lived in the same home for more than 60 years, having your property taken can be traumatic and heartbreaking. It is painful to watch something you've built disappear. The place where you raised your children, the land that you thought would be in the family for generations. The process is called land condemnation, which sounds as if there's something wrong with your house or land. But it's just a legal term that means some organization has the right to seize your property. Land taken must be used for some public good, which can include building a road, laying utilities, building or expanding a hospital, erecting a cell phone tower, or any number of other uses. Who can condemn your property? Federal, state, county, and city governments, and even private businesses, as long as they are able to show that the seizure is for a public purpose. Among the groups that commonly condemn property in North Carolina are the Department of Transportation, the Department of Administration, cell phone and telephone companies, pipeline construction companies, railroads, utility companies, hospital and housing authorities, and mosquito control and sanitary districts. When you're fighting huge entities like these, it's easy to lose hope. But if your property is condemned, you still have rights. You may not be able to save your land, but you can take steps to get the best possible compensation. The first step is to contact an experienced North Carolina land condemnation lawyer as soon as possible after you're contacted by the government or corporation with an offer to buy your land. Do not talk with anyone over the phone and do not make a counteroffer, even if it's just to feel them out. You never know when something you say can come back to be used against you later on. Legally, your land may only be taken from you for a public or commercial use if the purpose of the property taking is to benefit the public. The first thing a land condemnation attorney will do is determine whether the condemnation will truly serve a public purpose or if the condemnation is frivolous. If it is frivolous, an attorney can help you fight to keep your land. And if the condemnation can't be prevented, an attorney can work to ensure that you are paid just compensation for your property. In addition, you may be able to recover moving expenses. If you receive a notice of condemnation, it's imperative that you seek legal help immediately. The sooner the better. There are time limits for when you must take legal action. Depending on what entity is condemning your land, the time limit may be as little as 120 days, after which you could lose your right to challenge the condemnation or to receive the full amount of compensation you're entitled to. Plus, many attorneys, including my firm, practice law on a contingency fee basis. That means you don't owe us any attorney's fees unless we win. So it won't cost you a dime to seek out legal advice and protect your interests. Land condemnation cases are complicated and the stakes are high. You need experienced legal help on your side. If you have questions about land condemnation, feel free to call us at 1-800-4LAW-MED or visit our website at lawmed.com/land condemnation. The condemners won't wait, life doesn't wait, so call Henson Fuerst today.